5, 4, 3, 2, 1. It has been argued for the petitioner that in the cited full bench authority supra no appeal had been filed and therefore the said authority is distinguishable on facts from the present case. It has also been pointed out that in the said authority it has been laid down that suo motu power of revision can be exercised even in a case of an appealable order and in a case in which no appeal has been filed. However, this aspect also does not deserve a very serious consideration and need not detain us any longer for the purposes of the present case. Filing of appeal postulates filing of appeal by a competent person and that too within the framework of the law. An appeal filed by a totally unconcerned person after 5 years of passing of the relevant order cannot, in the opinion of this court, put a fetter on the legitimate exercise of the said power conferred under section 50 of the code. Such an appeal is no appeal in the eyes of law. It has further to be seen that otherwise it would be quite easy to forestall and thwart the exercise of the said power by getting a time barred appeal filed by some unconcerned person. It has been further argued that since the said proceedings were drawn on the basis of a complaint lodged by the respondent number 4, the said proceedings should be treated as proceedings initiated on the basis of an application for revision. This argument has also no merit and deserves outright rejection. By the said complaint, certain facts only were brought to the notice of the competent authority who, on his motion, drew the proceedings under section 50 of the code. It has been in the last argued for the petitioners that though no time limit has been prescribed for exercising suo motu powers of revision, yet they should be exercised within a reasonable time. For the said proposition in State of Gujarat versus Patel Raghunatha, AIR 1969, SC at page 1297 has been cited for the petitioners. In this regard, it has to be seen that it is a cardinal principle of law of limitation that prescribed period, if any, of limitation starts running from the date of acquiring the knowledge of the relevant fact giving rise to the cause of action. In the present case, the relevant lands were recorded in the name of a deity. The collector started proceedings as soon as the fact of alleged mutation in the names of the petitioners was brought to his notice. Taking action within a reasonable time is a relative term. In the facts and circumstances of the present case, action was taken within a reasonable time. In view of the reasonings mentioned above, the present petition is devoid of any substance and is rejected with cause. The petitioners shall bear their own costs and shall also bear the costs of the respondents. Counsel's fee ₹500 if certified. इस वीडियो के डिस्क्रिप्शन बॉक्स में इस पैसेज का टेक्स्ट दिया हुआ है.